Welcome to this free immigration help channel. Today is May 29th, 2024, and we are getting into the volume 213 of me answering your immigration related questions. As always, before beginning this video, as I mentioned in every video, I'm going to mention it here. I am not an immigration attorney. This is not legal advice. All the information provided in these videos on this channel are directly from official government sources like the Department of State with their visa bulletin and the USCIS, which is US Citizenship and Immigration Services official website, uscis.gov. So let's start with the very first question coming from Gazi007. I am on an IWE2, so national waiver, employment based, priority date 28 December 2022, and documentarily qualified since 8th January 2024. All right, so about, sorry, my math is horrendous, about 4 months and 20 days, so like 5 months. Oh, about 5 months now. Okay, the final action date is current, but still waiting for an interview. What's your thoughts? Gazi, thank you very much for asking. So great news is that your immigrant visa is already available. The only thing that you're waiting on right now is for, well, again, your interview is most likely already scheduled. The reason why you don't know it is because they only announced the interview 30 days before the actual interview date. So if your interview is scheduled for, let's say, for example, September 2024, which is realistic, if, you know, depending on which country you're from, depending on where US Embassy is, you know, if the immigration traffic is busy, if the US Embassy in general is busy in the country where you're from, it might take longer. Some of the countries, like for example, Philippines, US Embassy in Manila, Philippines, they have like 2.5 year wait for just an interview after the immigrant visa becomes available. For a lot of countries throughout the world, on average, right now it seems to be about year, potentially year and a half. But again, some of the countries where is not much of an immigration flow, it might be faster than that. It might be 6 months, can be 9 months. So yeah, within this year, getting your interview is realistic. But let's say it was scheduled for September 2024. First, let's say September 1, 2024 is the day of your interview. You're not going to find out about it until August 2024 because they have to announce it 30 days before the interview date. But with that being said, if you've been current for now, well, you were documentarily qualified on January 2024. So I would assume that you've been current for at least 3 months now. You've been current. Reach out to the US Embassy where you're going to be having your interview. Let them know that you are already documentarily qualified, that you are already current on the visa bulletin, and ask them if they can give you the information when the interview was scheduled for, or if at least they can tell you approximately how long the wait time is. Sometimes they do because it's not official announcement over the phone. Sometimes they don't. If they don't be upset. And for everyone, you know, I always recommend strongly, if you are reaching out, if you're talking to the customer service of any of this, you know, whether it's USCIS or whether it's US Embassy, always be polite. Even if you don't get the answers, just say thank you and that's it. Because it's pointless to argue with them, you can only make it worse. I'll give you the link for all the US Embassy's website. Here it is, it's official government website. And we're gonna move on to the next one. From Love, what is that? Lovjeet Singh. Sorry if I'm mispronouncing the name. Hi, I filed I-130 form for my wife. She's outside of US and USCIS scheduled interview of mine, not for my wife. Why they scheduled my interview instead of my wife? Lovjeet, great question. I have no idea. I never heard anyone as a petitioner being scheduled an interview, an I-130 interview. Okay, a few things I'm going to ask you. Are you sure this interview is for I-130 petition? That's number one. Number two, are you sure that's an interview notice and not, for example, biometrics appointment? Because if it's a biometrics appointment, that's normal. You're going there, you're doing the fingerprint, you're taking the picture, that's normal. They do that for the I-130. But the interview, unless it's some kind of unique case where they need to verify something, where potentially they're suspecting something going on, and they have some kind of questions they need to ask you personally, I have never seen anyone as a petitioner being scheduled to interview on I-130 petition, especially husband-wife like this. So yeah, I would say two things. Verify that this is the interview for the I-130 petition, if it is the interview. Number two is verify it is the interview and not the biometrics appointment, because if it is, it's no problems. But yeah, if it really is the interview and it is for your I-130, I'm assuming that there is something that they need to ask you personally, and if they need you to show up for an interview, then yeah, definitely do that. Follow the instructions, and hopefully nothing out of the ordinary. But I would really appreciate if you can come back to this channel and provide the update, because I am definitely interested to hear what's going on and what's gonna happen, because I've never seen personally an interview scheduled for a petitioner like that. Okay, moving on to Sayed Bukhari. Sayed says, very helpful. Sayed, glad that was helpful. Moving further to Renee Marroquin. Hello, our church wants to employ a person using an R1 visa who is on a visitor visa currently in the US. Can we do this while they're here visiting? Yes, absolutely. How do we fill that out in the form? Thanks. Renee, thank you very much for your question. So there is no particular instructions per se to mention in I-129 apart from the physical address. So let me open up the I-129 so that I have it in front of me. Here it is. And I am pretty sure it does have the location for the, so petitioner information is going to be the petitioner, the employer. In this case, your church. So the church is going to be the employer in this case. This is going to be the petitioner. Now, information about this petitioner, you're selecting all of this. Now, the beneficiary information is going to be the information about the person that you are petitioning for. So let's see if we do have anything in relation to their location. So we got type of beneficiary, got an entertainment group, no, provide name of beneficiary, provide other names, other information, date of birth, social security number, alien, country of birth, province of birth, country of citizenship. If beneficiary is in the United States, complete the following. Okay, so there is a specific part, and it's in part 3, number 6. If they are in the United States, that's it. This is what you are entering. Date of last arrival, I-94, passport travel number. So yes, there is actually a specific, let me see. Oh, I see. So this actually form, this I-129 form, I think I'm gonna have to make an updated video, because this video that you're looking at is back in 2023 that I was making. And looks like the I-129 petition has been updated just recently, April 1st, 2024. I'm not sure if this was before or not. It might have been. But anyway, as of right now, there definitely is a separate section for the beneficiary if they are in the United States. And here it is. The part 3, item number 6 and 7, current residential US address. So you will be entering that information here. And yeah, so let me again post the response, and I'm going to give you the link just in case so that you have that directly to the form. And if you have any questions along the way, don't hesitate to come back to this channel, and I will be always happy to answer. All right, let's move on to the next question from DD24. Hi sir, good day. Can you explain to me what C, current, means in any of the graphs in the family visa category preference? Means when, for instance, in the F1, switch to graph A, switch to C, current versus the graph B in the latest update on that date on F1 of graph B. So DD24, thank you very much for the question. Great question. So current means that there is no backlog for that category. It means that if it is current on the graph A, it means that whatever the priority date is, doesn't matter. immediately the immigrant visa is already available for that category once the petition is approved by USCIS, once the I-130 petition is approved. Same thing for the graph B, which shows the portal, the NVC portal opening up. If it is current on the graph B, again, doesn't matter what your priority date is. If in this particular category it is current, once I-130 is approved by USCIS and transferred to the NVC portal immediately opens up. That's what it means when it is current on the graph B. NVC portal opens up immediately. On the graph A, current means the immigrant visa is immediately available. After, obviously, you go through all of the... You still need to go through documentary qualification and all that sort of stuff, but once the I-130 is approved, that's it. Because it is current, it's not dependent on the priority date, waiting for your place in line, basically, on the backlog that we are experiencing with the visa bulletin. All right, so let me post a response and we're going to move on to the next one from JQC Healthy Fit. If I have pending petition, can I still apply tourist visa? What and how to improve chances to be approved? Petition for I-130. And if I'm in Canada but Philippine citizenship, can I apply in home country instead of where as I am residing? And then looks like there is some more. Oh, looks like it's the same one. Okay, great questions. Thank you for asking. So I'll start with the very first one. It can go both ways. It really is at the courtesy of the US Embassy, where you're going to be going through your visitor visa, non-immigrant visa interview. And it can go both ways. For some consul, they can take a look at it and say, sure, you have your, immigrant petition going, and meanwhile you want to go visit the country. That is completely normal. You are not trying to immigrate right now, but yes, you do have intentions to immigrate eventually. But this time you want to go and visit your family, visit the country, see how it is. Yeah, I don't see any problems with this. Visa granted. For somebody else, it might be like this guy or girl is waiting for an immigrant petition. So they have an intent to immigrate to the United States. And now they're applying for non-immigrant visa. So they have intent to immigrate, and with intent to immigrate, they're applying for non-immigrant visa. And that's a big no. Denied. It can go both ways. It really is at complete discretion of US Embassy, unfortunately. It is really sad, and honestly I keep mentioning it every time I get a similar question. I keep mentioning it. I would like to see personally, I know nobody from government watches these videos, but if somebody does, I would really appreciate a legislation or whatever for a new type of visa, which is not particularly non-immigrant, but is not particularly immigrant either. It's kind of a hybrid in between, specifically for family members who have the I-130 petition pending for them, the beneficiaries who have the I-130 petition pending for them, so that they can come to the United States, so that they can visit their relatives, so that they can see what this country is all about. It's better for everyone. It's better for the families. It's better for the country as well, because they don't just have immigrants who come in here without knowing anything, but they have someone who already been here before, who have seen the culture, who have learn a little bit about the history, learn a little bit about the politics, learn a little bit about, and now they're coming in as immigrants moving in. But again, what do I know? But to answer your question, it can go both ways. If you don't mind, because it's time, it's of course money, I think what the fee is for a non-immigrant visa, like $150 right now. So is it worth a shot? I think it's definitely worth a shot, because it allows you, to travel here and see your family. So I would not discourage anyone from trying to apply for non-immigrant visa while they're waiting for their I-130 petition, because it would be great, if you can come here and be with your family. But it can go both ways. It really is at the discretion of the embassy. So be prepared for both. How can you improve the chances? Just be honest. Just be honest, say, yes, if they ask you, and most likely they will ask you about the I-130 petition, say yes, my parents, my brother, my spouse petitioned for me, yes, absolutely. But right now I just would like to go and visit them, and I would like to see, the country, and that's it. That's really the best thing to do. And as far as your second question, Canada, but Philippine citizenship, yeah, absolutely, you can definitely do that. That's not going to be any problems at all, because you do have Philippine citizenship. So if you are, going to US Embassy in Philippines, that's no problems at all, because you have a Philippine citizenship. So yeah, and a lot of times, even if you don't have and you're going through a US Embassy anywhere else, there is really no restrictions to where you can go through an interview, whichever US Embassy, because everybody has different circumstances. You can be visiting other country and just going through, a US Embassy. It can create additional questions, absolutely, but if you have a good enough reasoning, explanation, it should be sufficient. All right, let me post a response on one of these comments, and I'm gonna just address the other one, and we're gonna move on to the next one from YP7 at 1140 in 1C. Why does a refugee has to still apply for travel document while he already have their green card and can travel with that? Why is there such option? Detailed answer will be much appreciated. So that was a question on I-131 application for travel document, and that's a really, really good question. Great question. So the reason why there is an option for someone who already had the refugee or asylee status granted, and based on that status they already received their permanent residence, is because a lot of times, as someone who's been through the refugee or asylee process, most likely they have compromised their passport from their country where they claim asylum from, or their refugee status from, where basically they ran away from, because they can't, they can't go to the embassy here in US of that country and say, hey, I need an updated passport, because they're claiming protection from that country. Or they cannot travel back to update their passport, and you do need a passport for international travel. So what the I-130, the travel document, does, it replaces that passport of that country that you ran away from, that you cannot have an updated passport from. It replaces it for you and serves as a passport. So yes, permanent resident card, it allows you to enter back into the United States because you're a permanent resident of the United States. But traveling between the countries, it's done. You have to have a passport, and if you cannot get it because you had a refugee asylee claim from the country, that's why you get that refugee travel document. All right, so let me post a response, and we're gonna move on to the next question from user. Sorry, sometimes YouTube does not show me the names. Hi, amazing video, amazing channel, thanks for watching. Question: if I already been in the US and do a change of status, do I still need to fill the DS-160 form? If yes, what do I choose on the place of interview? USA? So you were asking a question on I-129, petition for non-immigrant worker. So I'm assuming you came into the country, maybe on I-129, maybe on a work-related visa, non-immigrant. And yeah, because you're asking about DS-160, and it's an application for a non-immigrant visa. So if you are already in the United States and you already have the status, and you already have, let's say, an employer, because this is work-based, because this is I-129, and they are maybe renewing your employment with them, renewing your visa, or potentially changing status maybe from one employment-based visa to another one, then no, you don't have to do that, because DS-160 is specifically for the US Embassy. It's specifically the application for the non-immigrant visa. So when you are applying for a new non-immigrant visa and you have to go through the embassy, that's when you're doing the DS-160. But if you're already here and it's just a renewal of your status, then you don't have to worry about the DS-160 at all. And honestly, I'm not sure if you even came across the DS-160 with this I-129 application, because the only time you come across the DS-160 is when you are actually trying to schedule your interview with US Embassy for your non-immigrant visa appointment. So if I understood this correctly, and I've done explaining in an understandable way, good. But if you do have, if I didn't, please let me know in a follow-up comment, and I'll try to address it in one of the next volumes. All right, let me post a response, and we're gonna move on to the next one from Trudy Bubs. Hello, sir. I have my interview in a few weeks. However, I have a 1-month-old baby. The baby was not a part of the application when I was documentarily qualified 3 years ago. How do I add my baby as an applicant before my interview at the embassy? I'm F1 category and other countries. Thank you. Trudy, well, first of all, congratulations with the baby. Definitely reach out to the NVC. It's really not gonna do much, but it is good practice to keep them updated. All you have to do is submit the public inquiry form, and I'll show you how to do it. I'll give you the link directly to it. Just enter all your case information, let them know everything, let them know that the interview is already scheduled, but you had a baby one month ago. Just add the birth certificate for the baby into the response. I'll show you how to do that and send it on their way to them. Also, definitely reach out to the US Embassy and let them know exactly what's going on and say, hey guys, this is the situation. I have my interview scheduled. You know, I'll be coming. I wanted to let you know that it's not going to be just me. It's going to be me and my newborn. And obviously you will bring all the, birth certificate, whatever, due for the interview. And it should be, there shouldn't be any problems at all. But it is definitely a good thing to update them beforehand, both NVC and the US Embassy, just to be on the safe side, because that's really what we're trying to do. Make sure that we've done everything on our end and we got everything covered as much as possible. So let me get the link for the public inquiry form. And for everyone who's watching this video, if you need to reach out to the NVC National Visa Center, this is how you do it. This is the best way to do it. They're pretty quick to respond. So from this page right here, and you can find the link for this page in the description below. This is the Visa Bulletin page, and this is the website for US Department of State. We're gonna click on Contact Us, and from this page, I opened it in a new tab so that I don't have to close the Visa Bulletin. From this page, we're gonna click on US Visas Contacts, and then we'll scroll down a little bit, and in the very first line, first row of this table, you will see Email Public Inquiry Form. So click on Public Inquiry Form, scroll down a little bit more, and you will see this line right here, Online Immigrant Visa Inquiries Only Public Inquiry Form. So click on this. So there you go. This is the Public Inquiry Form, which is just the online form that you fill out, basic online Contact Us. So right here, you will put your NVC case number. You should definitely have that. Principal applicant's full name is going to be beneficiary's full name. So it's going to be your name. Principal's applicant date of birth is going to be your date of birth. Petitioner's full name is going to be petitioner who filed the petition for you. Who are you? You're going to be selecting principal applicant, beneficiary, your email address, and then in the inquiry below, just type it up as you would, introduce yourself again, mention your case number and explain the situation. Say that the interview is already scheduled, when it is scheduled for, and let them know that you had a newborn, you have a newborn baby, and you will be coming with a baby to the interview. And in the attachments here, scan, make sure it's a very small size but legible scanned birth certificate for your baby, and attach it here and send it to them. And then once you're done with that, I'm gonna give you the link for this. Link 1. So this is the public inquiry form, and then the link 2, I'll give you the list of US embassies. Just find your country on the list, and whichever country it is, well, let's say Finland, and it will give you their telephone number. And if it doesn't give you telephone number on this, just click on the embassy itself, and on the embassy's website you will be able to find, they usually give their phone number either on the same page, or they have like a contact us, and give them a call and say, hey, I have a urgent matter, I wanted to let you know, and they will be able to accommodate you. So let me copy this. And did I say link to? Yes, I did. Let me give this space. There we go. All right. Good luck at the interview. Once you get your immigrant visas for you and your baby, please come back to this channel and let me know. I'd really appreciate it, because I really like to read the good news as well. All right, let's move on to Patricia P. Hi, would you be able to tell me when my daughter will get her interview in Trinidad and Tobago? She is documentarily qualified in January 2024, and her priority date is February 2017, F1 category. Thank you so much. Patricia, you're very welcome. Let's see what we can do. So she's already documentarily qualified, and it was in January 2024. So she's been documentarily qualified for about 4 or 5 months now. Priority date is in February 2017, F1. So Trinidad Tobago is going to be all chargeability area. So let's take a look, see what's going on the visa bulletin for F1. Currently looks like it is July 2015. And your daughter's priority date is in February 2017, so there is still about a year and a half, roughly, if we see the consistent movement on the visa bulletin, which is 1 month every month. If we see it moving faster, obviously it's going to be less than a year and a half wait. Hopefully we see it faster, that would be good. But as of right now, roughly about a year and a half before her priority date becomes current. And then after her priority date becomes current on graph A, which is when her immigrant visa becomes available, that's when they start scheduling the interview. Depending how long they take in Trinidad and Tobago, US Embassy, depending on how busy they are, you know, on average, the countries that are not too busy immigration flow, it seems about a year now people are waiting for their immigrant interviews. So roughly, very, very roughly, potentially we're looking at about 2.5 years before your daughter's interview. It can be a lot less if the visa bulletin keeps moving faster than, you know, if it's going to keep on catching up. As of right now, really the only thing left for both you and your daughter is just keep checking the visa bulletin every month. The new one comes out, and hopefully we see some positive movement. But yeah, as of right now, that's what we are looking for. And honestly, if anybody is from Trinidad Tobago and they had their interview scheduled, I would really appreciate them commenting. And really, wherever you're from, Trudy, you as well, let me know where you're from and how long you waited for that interview before it was scheduled. Because the time that I'm really looking for is after your immigrant visa became available. So your priority date became current. Since that day, your priority date became current. How long you've been waiting for your interview? That is really the time that is dependent on the US Embassy and how busy they are in whichever country we are, you know, in question. And I do have the list of countries. I don't have a lot right now, but I will keep updating as people are letting me know how long they waited for, because that's the best indication. All right, let me post a response and we're going to move on to the next one, probably our last question, also from Trinidad and Tobago. Look at that. So my mom, from MJ, my mom applied 2015, got approved December 2020, and we now have an interview date. However, I was told that my son, who is now 23 years old, has aged out. What do I do? I'm in Trinidad Tobago. Sorry about that. So a few things when it comes to stuff like this, and I always recommend whenever it comes to CSPA, is to verify for sure that he definitely did age out. Because Sometimes they don't do their calculations. We don't want to rely on just somebody said something. So verify it for yourself that your son definitely ages out and he does not qualify under CSPA. And what you need to do is you need to look at the original receipt, the notice of receipt that your mom received from USCIS. And that would be the one with the priority date back in 2015. And then you want to look at the notice of action that your mom received from USCIS, saying that the case was approved by USCIS. So not NVC part, not documentary qualification, not any of that. Just how long the case was pending with USCIS. And if it's been pending for over 2 years, then your son definitely has a chance under CSPA to qualify as a child and go through the interview with you, because this is what you can do. Under CSPA, you can subtract the amount of time the USCIS I-130 petition was pending with USCIS from the age of your child on the day of the interview. And if that brings the age of the child down under 21, which in your case, you only need about 2.5 years, that's it, then they qualify under CSPA. So verify that. That's number one thing for you to do. And if your son really did age out, then you need to start looking at other potential avenues for your son to come with you while his own petition. So you will, once you get your immigrant visa, once you enter United States, you will be able to petition for your son, just like your mom petitioned for you. Of course, that's going to be a long process, and it will be obviously a lot longer than if your son could have, came with you immediately, gotten the immigrant visa as well, unfortunately. But if you can find, whether it's a non-immigrant visa, visitor visa, student visa, exchange programs like J1, if you can find something like that for your son to at least be able to travel back and forth, that makes the process a lot easier because there is no separation. So that's really a few things that I can recommend. But yes, number one thing is make sure that that he definitely verify those numbers, those dates. And I wanted to go back to Patricia's comment because let's see. So MJ said my mom applied 2015 and got approved December 2020. So that's got to be F1 if it's a mother petitioning. So 2015, that means that they have become current right around, so depending on when 2015, but it cannot be, again, it's hard to tell how long they have been current because the visa bulletin does not always move 1 month every month. Sometimes it moves faster. So you can be current now for 3 months, but you can be ahead of the visa bulletin 6 months, if that makes sense. So it's not exactly an indication. But still, you can more or less roughly make a judgment how long it takes for an interview to be scheduled in Trinidad and Tobago, and it doesn't seem to be that crazy wait because people who are in 2015, as of right now, as of June 2024, they are becoming current on the visa bulletin. And in MJ's case, 2015, let's say they have been, they had their, for example, in January 2015, let's say they have been current now on the visa bulletin for about 6 months, roughly 7 months. Can be longer, and most likely it is longer because again, visa bulletin, we did not see that consistent movement for F1 specifically. So yeah, looks like they were roughly waiting, for somewhere between 6 months and a year because it's still within 2015. So yeah, Patricia, there you go. That's a good indicator for sure of how long approximately your daughter will be waiting after her immigrant visa becomes available. But again, it might be a lot faster because hopefully we'll see some positive movement on the visa bulletin. So yeah, just keep checking the visa bulletin every month the new one comes out, and on this channel I do a video every time it comes out comparing it to the previous one. So yeah, I'm looking at the visa bulletin myself, so I'm definitely in the same boat as everybody else. So thank you everyone for watching. Hopefully my answers were helpful. If you have any follow-up questions, don't hesitate to ask them. Just make sure not to respond to my comment within your comment, because I don't see those responses. Just submit it as a separate comment under any video and it will show up here on this wall. So thanks again, God bless, and I'll see you all in the next video.